G'day, I'm Stephen Page from Page Proven Family and Fertility Lawyers, and today I'm talking about how human rights are implicated with surrogacy, or put it the other way, how surrogacy ties up human rights issues. If you want a full description of all the human rights that I'm able to identify in any event that somehow relate to surrogacy, I've put them on my website. This video isn't that full list, because that full list is very long and there's only so much time that you have to watch and listen to this. So I'm going to focus on a few core human rights. The first is the right to access assisted reproductive treatment and the right to procreate. This has been put in a number of ways. The US Supreme Court, well prior to IVF having been invented, said at the time of World War II that the right to procreate is a fundamental human right. That was in the circumstances where Oklahoma law said that if you were 3 times convicted of a particular offence, then you were to be forcibly sterilised. And it's no surprise that in response to that, the Supreme Court thankfully said that the right to reproduce is fundamental. More recently, there have been movements by 2 courts, the European Court of Human Rights and the Inter-American Court of Human Rights, which recognise the right to access assisted reproductive treatment. And they are, not surprisingly, under the European Convention on Human Rights and the Inter-American Convention on Human Rights. The provisions that are in each of those conventions are very similar to those under the Universal Declaration of Human Rights, which Australia has signed up and which we see repeated in human rights laws which currently exist in the ACT, Queensland and Victoria. So this first right, which concerns the right to privacy, has been held to be a fundamental one, and the European Court of Human Rights looked at it in the context of a man who was convicted from recollection of murder. He was in jail. He had a wife whom he had married while in jail, and they wanted to be able to have a family. And the UK government had said, well, that Mr. and Mrs. Dixon, that was their names, were not entitled to do that because Mr. Dixon was a prisoner and he wasn't entitled to access assisted reproductive treatment. The European Court of Human Rights said that it was a fundamental human right to be able to reproduce, to procreate, and because it was therefore an interference with his right to privacy, he was entitled to proceed. The UK had acted outside its entitlements. The second that we have seen this was in Costa Rica, where Mr. and Mrs. Murillo, amongst other couples, had tried to access IVF. Now, Costa Rica it seems to have been the only country that listened to the Vatican when it came to IVF and said, no one can access IVF. There'll be no IVF. So one of the things the Inter-American Court of Human Rights looked at was how prevalent IVF was across Latin America. And lo and behold, it seemed seemingly everywhere amongst Latin countries, but not in Costa Rica. And they said it was a fundamental human right to access ART. And then in the follow-up case, they said that, well, if they need to access surrogacy, then obviously it's part of that fundamental human right of accessing ART as their right to privacy, to then undertake surrogacy. We've seen discussion about these human rights and not about those persons with disabilities, because we've got the Convention on Dealing with Persons with Disabilities, nor so much about other conventions, but certainly the Inter-American Convention and the Rights of the Child, in a series of decisions by the Supreme Court of Justice of the Nation, in other words, the Supreme Court of Mexico. And we've also seen it discussed at length by the Constitutional Court of Colombia. I'm going to focus in this video about the Supreme Court of Mexico because I think that court nails the issues to do with surrogacy. Both courts rightfully say, look, you've got to be really concerned about surrogacy. It's got to be properly regulated, but we want to make sure that no one's taken advantage of. And in both countries, what we've seen is that there has either been regulation that, at least in the terms of Mexico, shouldn't have occurred, and in terms of both countries, generally no regulation about surrogacy, and calls by the Supreme Court and the Constitutional Court, respectively, for legislative regulation. The first decision by the Supreme Court of Mexico was in 2018. It concerned a gay couple from Yucatan, and they had undertaken surrogacy there with a single surrogate. And what they were most upset about was that the birth registration officials had placed the biological father and the surrogate's name on the birth certificate as the parents and not both men. Now, this issue had been previously considered by the Supreme Court of California, which had taken the view that what was the point of the deal? What was it to implant the embryo to enable the woman concerned, the surrogate, to be a parent, or was it to implant the embryo to enable the intended parents to be the parents? And they concluded that when you look at the intention of the parties, the intention was for the intended parents to be the parents, and therefore they were the parents. The Supreme Court of Mexico took a similar view, but it also looked at these other issues, and they were, well, what are the rights, what are the fundamental rights of family creation, of procreation? And to paraphrase their language, families come in all shapes and sizes. The idea that the only form of families are heterosexual married couples who are conceiving children naturally is gone. Yes, they're there, but certainly so is everybody else. Single women having children, single men having children, lesbian couples having children, and gay couples having children, among others. And there needed to be recognition. And the two things that the Supreme Court picked up on, in my view, were the right to procreate, namely of the couple, that they were the driving force to have a child, and that should be recognised, and they should not be discriminated against, but also the right of the child, that the child has a right to identity. This is taken up, incidentally, in Article 8 of the UN Convention on the Rights of the Child, and the child's best interests. And the child's best interest and the child's right to identity demanded that its parents be recognised, so that both men were recognised as the parents. The court also said in their judgment, well, in Mexico, we don't discriminate against gay people. That's gone in Mexico. We are equal. And so we see this strong flavour that there shouldn't be discrimination. That's certainly consistent with the International Commission of Jurists and Human Rights Experts, who quite a few years ago met in Yogyakarta in Indonesia and said, what are the international human rights principles when it comes to LGBTQIA plus people, to use the current alphabet name for people like me? And the answer was, well, here they are. And Principle 24 was that there is a fundamental right to found a family for LGBTQIA plus people. Then in 2021, the Mexican Supreme Court had to look at this issue again, because many years ago, the state of Tabasco had a surrogacy boom. And I had clients going there back then in 2014 or thereabouts. And they got so many international intended parents going there that Tabasco said, we're changing the law, no foreigners need apply. And this particular case concerned a gay Spanish couple who had gone to Tabasco well after this law had passed, because this was a decision in 2021. And they said it shouldn't discriminate against us. The Supreme Court looked at this again and said, yes, as we said on the previous occasion, in effect, that access to surrogacy is a fundamental protected human right. And in Mexico, we don't discriminate against foreigners. So foreigners have the same rights as Mexican citizens. So really such a significant decision, and therefore the law in Tabasco was ruled invalid. But what about the rights of the surrogate? The Supreme Court has identified the rights of the intended parents, namely the right to privacy and be able to access ART and surrogacy, consistent with those decisions in Murillo of the Inter-American Court of Human Rights and the right of the child to best interests and privacy. But what about those of the surrogate? Well, they were addressed most recently in July 2025 with a decision where the Supreme Court said, well, look, we asked the Congress to pass laws to regulate surrogacy. You haven't done it. So if you want to come to the courts and get an order, which is what everyone wants to achieve, then here are some things that have got to be done. The Supreme Court was concerned to make sure that surrogates were not taken advantage of. No one in their right mind should want to see exploitation and trafficking of women and children, and certainly the Supreme Court identified that they want to make sure that those practices are stamped out. Aside from being illegal, they wanted to make sure that in terms of agreements that were reached, that there wasn't any oppression of surrogates. So the first thing that they said was, when you've got an agreement with a surrogate, you've got to look at that, the whole of the circumstances, but is it fair? It can't oppress her rights. And they then gave some examples about how not to oppress her rights and to uphold her rights. And they included these things. Look at the agreement as a whole. Does it look at the whole as being oppressive or unfair? The second one is, before she enters into the deal, has she had independent legal advice? Has she got medical advice that she can rely on? Has she got psychological assistance that she can rely on? So she knows what she's going into, and therefore, if she's entering into a contract, that she's doing so of her own free will. During the course of the pregnancy, that she has bodily autonomy, and so she can decide if she doesn't want to proceed at any stage, and that the surrogate has counselling available to her during the course of the surrogacy journey. And at the end of the journey, when a court order is obtained, rather than what was seen in that case, where one lawyer represented both the intended parents and the surrogate. Now, that could never fly in Australia, but in any event, that's what happened in that case. The Supreme Court said, no, you can't do that. The surrogate has to have her own independent legal representation. So when I looked at that case, I thought, well, lo and behold, these are the kinds of things that we take for granted in Australia, but isn't it wonderful to see that the Mexican Supreme Court is doing that? It's upholding the right of the surrogate to her body and her own individual human rights by active intervention to ensure that she has independent legal representation, and also the medical and psychological and bodily autonomy. So that's Mexico looking at this. And I just want to touch on one thing that's come from the Constitutional Court of Colombia. The Constitutional Court of Colombia has gone down a similar route, but most significantly, there were two decisions in 2024 concerning the child and the child's right to an identity. In Colombian law, the child has the right to nationality arising from blood, from descent, from the DNA, not from being born there. So quite different, for example, to the US, Canada, or Mexico. At birth, the surrogate is shown on the birth certificate. The law of Colombia, I should say, as set out by the Constitutional Court, is that those who intend to be the parents are the parents, and those who don't intend to be the parents are not the parents. In other words, the same thinking as that's seen in California and that's seen in Mexico. But what if the child obtains a Colombian passport based on the surrogate, because the surrogate is shown on the birth certificate at birth, and then when her parentage is formally revoked later on, what if the child then loses that Colombian citizenship? And that's come up twice in Colombia in decisions of the Constitutional Court. In the first case, it was an American father, and he wanted the child to have a Colombian passport. And that case was rejected by the Constitutional Court because the child had a right to an identity and nationality because she had US citizenship through her father, and from that US citizenship had a US passport. So he wasn't successful in that quest. The second case, however, concerned a Ukrainian dad, and he'd done surrogacy in Colombia. The child had flown on the Colombian passport, again by virtue of the surrogate being shown as the mother initially, all the way to Spain, at which point the passport was revoked. Presumably by that stage, the surrogate was no longer the mother. And from that point on, the child was stateless. Now, somehow, and I don't know how he managed to do this, the father managed to get the child all the way back home across several borders in Europe. He wanted to move to Australia at one stage to work, but we said, no, won't allow her in because she doesn't have a passport. Sorry, won't uphold that human right. But what the Constitutional Court said is that under the law of Colombia, even though the child derives their citizenship from the parent, that's also fundamental, that's subject to the fundamental right of the child's identity. And in this case, the child's identity was removed. The UN Convention on the Rights of the Child also talks about states, countries not ensuring that children aren't left stateless. And here was a situation that through lack of thought, the child was left stateless. And as a result, the child was granted Colombian citizenship. So the child was no longer stateless and the child could have a Colombian passport. And I'm told by a Colombian colleague that as a result of that decision, family court decisions in Colombia are now very carefully looking at the question prior to the court process to remove the surrogate as a parent, to see what impact that has on the child, to make sure that the child is not left stateless. So that's a summary. We have this conflict playing out between Europe that talks about the child's right to identity, identifying the surrogate as the mother, and that seen in the Americas that identifies, as we've seen from California and Mexico and Colombia, that the intended parents are the parents and that there is a fundamental right to procreate or to reproduce. So those are the tensions that are seen with surrogacy. What is clear with surrogacy is that surrogacy is a new area for consideration of human rights worldwide, and there is this fundamental conflict, but we'll see how it plays out. It's important, however, that at all times the human rights of all concerned in the surrogacy journey are respected. Thank you for watching and listening. I'm Stephen Page from Page Proven Family and Fertility Lawyers, and you've been watching and listening to the Australian Family and Fertility Law Podcast.